James Allen, I'm absolutely thrilled for you to come along today. It's so important for our community. Generally, to give you some context, the community of people who come in and listen to these podcasts are essentially people who are curious as to why they should vote no to the Aboriginal and Torres Strait Islander voice to Parliament. And so the idea of having somebody who's a highly experienced constitutional lawyer.
I feel I can put anyone to sleep.
Should be able to put us all to sleep.
Just give me a call if you have a bit of insomnia. I should be able to put anyone to sleep, really.
It's so hard to sort out the truth from fiction. There seems to be so many competing views. So to get an expert in on constitutional law and legal philosophy, I think it's going to really add, enrich people's knowledge about the debate. Before we fire into it, I will just give a quick bio of you. So we're talking today to James Allen. He holds the oldest named chair at the University of Queensland, where he is the Garrick Professor of Law. He's a native-born Canadian who practiced law at a large firm in Toronto and then the bar in London before moving to teach law in Hong Kong, New Zealand, and then Australia.
One step ahead of extradition.
That's right, moving on.
I remember that.
James Allen has published widely in the areas of constitutional law, legal philosophy, and Bill of Rights skepticism. And quite a large list of books that James has published and journals that he's been involved with. So it's absolutely fantastic to have you here James. So
that was very kind, thank you. People might know me best. I write weekly for The Spectator and occasionally for The Australian. So if they might have come across me there, I'm pretty sure they wouldn't have come across me anywhere else unless they are having trouble sleeping. But yes, well, it's very kind of you guys to have me, to be honest. Thank you very much.
Good. Yeah, no, I think you're really going to add to the debate. I mean, if I could ask just something very broadly, because you've travelled quite a lot, both Australia, New Zealand, where I think there's some similarities of a constitutional story, and Canada with its Indigenous and its constitutional story in relation to its Indigenous people. And
so there's similarity, Philip, in terms of the countries have signed up to the International Convention on the Rights of Indigenous People, but there's a big difference between Australia and New Zealand. New Zealand does not have a written constitution. It's like the UK. So there are three countries in the democratic world, they don't have a written constitution. Britain, New Zealand, and we can argue about Israel. They're sort of halfway in between. And so when you are in a parliamentary sovereignty like that, you don't have constitutional referenda. Everything's just a statute. And no one would have any problem with this as a statute, because if you don't like it, you can repeal it. One of the real, I am totally against this proposal, but one of many problems is that once you put something into the Constitution, it's more important than statute. It's more important than what is delivered by your elected parliament. It sits above it. And the people who interpret the written Constitution are the unelected judges. And my view is that they will become aggressively activist. One of the things we know from the U.S., because political donations in the U.S. are public, and when you look at law schools, the people who teach at law schools lean Democrat 9, 10, 12, 15 to 1. The lawyerly caste from which judges are chosen, people imagine 50 years ago, they would, as a generalization, the lawyers would have been to the right of the median voter. Today, they're massively to the left. And if you go into, you want some of the most race conscious or woke or identity politics conscious workplaces, just go into a big law firm in Sydney or Melbourne, bring your pronouns with you. And I'm telling you, so I'm a big fan of democratic decision making. I don't want to let the judges anywhere near this. I'll come back later and talk about the Love decision from 2020, where even without any provisions in the Constitution, the judges just made up this racialized test for who can be deported. And so we have a written Constitution. So like Canada, once we amend that written Constitution, that is a vehicle that can override, trump, gainsay the elected parliament. That can't happen in New Zealand. because they don't have a written constitution. It can't happen in Britain. So that's a pretty big difference.
I mean, so I understand you're saying that in New Zealand they do not have a constitution.
No, they have gone down the race-based policy making. There's no doubt about that.
Yes.
And they've gone for co-governance, and I think it's been pretty unpalatable. But in New Zealand,
because you've lived in New Zealand, a lot of people won't understand that.
Yes.
So
the thing about New Zealand is you have an election, and if the Right of Centre National Party wins this election coming up this year, nothing stops them from repealing every bit of legislation that sort of triggered this co-governance, race-based policy making. If you put something into a written constitution, it doesn't matter who wins the election. You're stuck with it. And so this is much more serious. And if the Albanese government were simply saying we're going to pass a statute to give some body like the Voice a go, would be pretty uncontentious. I mean, they've done it already with AITSIC, and it didn't work out very well. But what they're trying to do is immunize this from democratic, accountability. So whenever you change your written constitution, and people who are watching should realize, you think Australia is a pretty young country. We have about the 4th or 5th oldest written constitution in the world.
Yeah.
When you just think about Europe, all of their constitutions are new, much newer than ours, with the exception of Switzerland. 2 world wars took care of that. So we have a very old written constitution. It has stood the test of time. It's basically a recipe book for how democratic government works. And it has done a number of things. So effectively in the late 1800s, the founders in Australia, wanting to bring the colonies together, looked around and, what they did the sensible thing. They said, oh, we'll copy. And so our Constitution is as close to anywhere in the world for copying the American Constitution. So I'm Canadian. So that when it came to federalism, the founders here in Australia could choose between Canada and the US. They chose the US model of federalism. People here think it's normal to have a strong upper house like the Senate. It's not normal at all. I mean, the Americans have it, we have it, and the Italians have it. The rest of the democratic world, there's no strong upper house. In Canada, my native Canada, the upper house is appointed. It doesn't block anything. It's appointed. It's laughable that they block anything. And the same is true in Britain. The House of Lords, you in the year 2023, you as an unelected body are not going to override the elected body. So they can slow things down a bit. So most times in those countries, if you win an election, you want to balance the budget, you do it. Or, if you want to, here we have to bargain with this upper house and they make it really difficult. That's the American model. The difference is that in the US, they have a sane voting system for the upper house. And so if you're in Georgia and you're mad about what the other party is doing that controls the Senate, you can punish them in Georgia. We are in a worse position than the Americans because we have this aggressive STV proportional voting system for the Senate. And it brings in, a lot of small fringe type actors into the Senate. And if you're, not very happy with what one senator from Tasmania decides, who's gotten into the parliament because she comes from an extended family with 12 friends, there's nothing you can do. There's no recourse. And, we have copied the American model where each state gets the same number of senators. So in the US, it's 2 per state. For us, the way we left it to Parliament, the rule just is they have to be the same per state. So it's 12 per state. So if you live in New South Wales, you get 12. And if you live in Tasmania, you get 12. So your vote is effectively worth, 15 times more in Tasmania? And what the Voice is going to do, and this is one of many problems with it, it's going to add another layer. So we already have a sort of incredibly difficult to pass legislation system with a strong upper house. And now we're going to have this body, the Voice. And they say, okay, well, technically, Parliament can ignore the Voice, but we know that's not going to happen, right? There's the legal sort of theoretical framework, and then there's the reality. Even Mr. Albanese has said it would be a brave Parliament that ever stood up to the Voice. Well, I can tell you from the Canadian experience with the 1982 constitutional amendments, no one's going to stand up to this Voice body. So we're going to end up with paralysis.
So you're saying that nobody in the history since 1982 has ever stood up
Well, we don't have a voice body, but what happened in Canada was they were bringing in changes to the Constitution and they wanted to entrench a lot of power for the judges. And people went, oh, that's not democratic. And the proponents effectively said, well, we'll put in this provision that says the elected parliament can override judicial decisions for 5-year rolling periods for most of the rights. And they did that because many of these people really wanted this to get in. And so they kept saying, look, Parliament will have the last word, I promise. And
okay, so that's a similar concept to where we are with the voice.
Yeah,
that is, Parliament should have the last word.
The minute it came in 1982, many of the same people said, you can't use this. It would be illegitimate. You can't use it. So in 40 years in Canada, 40, the national parliament has never invoked that provision one single time. You know, they have never stood up to the judges and invoked it. And my guess is that's what will happen here. In theory, Parliament will be able to override the voice, this body. But in practice, left-wing Labour-type parties are not going to want to override the voice, and right-of-center coalition governments won't have the backbone to do it. And we know that's true because they haven't shown a backbone in 15 years. And you know, they never do it in Canada. They say, oh, we want to use this provision, but when push comes to shove, they never do it. They will not stand up against the lawyerly caste and the sort of activist caste. And so in practice, you're voting for a body that's likely to have an awful lot of say. And when you look at what's being proposed, we don't have any detail really. We're just being asked, do you support an alteration to the Constitution that supports this voice? And it'll be called, you know, Aboriginal and Torres Strait Islander voice. And it says it may make representations to Parliament and the executive government on matters relating to Aboriginal and Torres Strait Islander peoples. It doesn't say only on matters. So in theory, it can be on anything. And we know that the minute this gets enacted, the judges will turn may make representations into a right to be consulted. That'll become a constitutional right to consult. And if you want to get anything done, you're going to have to deal with this body, and the rent seeking will be huge. We know that's going to happen. And you know, there's also a structural asymmetry because you see it now just with the Senate. If you are a party that wants to spend money like crazy and do all sorts of big government things, the little tiny independent type senators will let that through because they get to dole out money. But if you say want to balance the budget or rein in the deficit, no one in the Senate will support you in the little parties. And so, you know, when the coalition wins, they can never get anything through the Senate. It's going to be exactly the same with the voice. You know, the voice will always be for more spending, and they'll always be for more everything big. And you know, if you're a small government right of center, this is just a disaster. And this is just we haven't even got into the legal problems yet. This is just the practical problems. And they're selling this whole package, I think, largely with emotional blackmail. You know, if you're not, this is.
Can I get into that for a second? But a moment ago, you read out the 3 draft clauses for the referendum, and there's one of the words there was representation. Now, as I understand it, and I'm not a constitutional lawyer, we live in a representative democracy, point one, and I ponder what an additional type of racially specific power of whether I can find it like that, but how that impacts upon the functioning of our democracy, but also within the context that there's this word that everybody uses in the paper is it's an advisory body, and that you know can give advice. But I don't see the word advice in the clauses to be inserted into the referendum. I see the word representation. Is there a difference between advice and representation?
You've got to distinguish between the theoretical legal position and what's going to prevail practically after this comes in. So my guess is that everything will become justiciable. The judges will point to this in the Constitution, and they will say, imagine where Parliament passes a bill and just
for the lay person, justiciable,
where you can go and contest what Parliament has done in the courts. Yep. So some things are not justiciable. Like if you declare war, you can't go and ask the judges to second guess that. Mm-hmm. So that sort of thing. But so the problem is in practice. What does it mean? May make representations. Well, the judges might decide that you have to first have a consultation. That would become a constitutional right to be consulted. And how long do they get to drag that out for? Nobody really knows, because we've gotten very few details. We've got almost no details. I don't know of another constitutional sort of proposed amendment anywhere in the world where the government has gone and said, look, we can't give you any details now, but if you're a good person, vote for this, because it's just a matter of good manners, and really just leave it all to us. And Parliament, you tick this off, and we'll sort out the details afterwards with the activist class. And a Parliament right now that the lower house is controlled by Labour and the upper house is controlled by the Greens, Labour, and one fringe independent coming out of Canberra who leans more left than the Greens. And so these are the people who'll be making the rules after the fact. I don't personally understand how Mr. Dutton hasn't come out against this already. I think it's a bit of a disgrace myself. He's playing a tactical game, I hope.
I sometimes think about the argument about details, and I understand that if we're going to make a change to the Constitution, that knowing what's involved seems rather important. But wouldn't it also be the case, or is it also the case, that details, in a sense, don't matter, because as time goes by, that is, any future Parliament can change the meat on the bones, the details.
Again, Philip, you're talking legally. Yes, in theory, they will be able to do that. In practice, once it gets locked in and it becomes a sort of activist body, you would require a lot of political courage to do that. And the experience from Canada is, in practice, no Conservative Party will take on this vested interest. And here's the sort of things we don't know. We don't know who's going to count as an Aboriginal person. Who's in, who's out. We're already overrepresented with Aboriginal people in the present Parliament. If you look at their percentage of the population and their percentage in Parliament. So they're already overrepresented. We don't know who...
Stay on that one as well, but that's an interesting one when you start to extrapolate it over the decades and the centuries to come. For example, at the moment, as we know, 70% of Indigenous people live in the cities and the suburbs of the regional cities. It's only really 30% who live in very harsh conditions out in remote areas. But of that 70%, the same number, are married to non-Indigenous people. And I ponder what, in other words, what is Indigenous when 70% of them are married to non-Indigenous spouses? That means the whole racial and cultural mix will evolve naturally, like we all have.
I agree with all that. The problem is Parliament will end up deferring to the Aboriginal activist caste, which, it's a very small percentage of the Aboriginal body. And so, again, as I said, we don't know going in who's going to be counted as an Aboriginal person. We don't know, in that phrase, matters relating to Aboriginal and Torres Strait Islander peoples. We don't know what that means. In theory, that means every bill that's passed by Parliament has, in a way, relates to Aboriginal people. So they're going to get a say, or at least a consultation right on every bill?
Well, as I understand,
we don't. Hang on, we don't know what may means. May make, we don't know what that means. We don't know how anyone gets to be in this voice body. It's like a blank check. And Mr. Albanese's playing a pretty clever game. He's just playing moral blackmail. You are not a good person if you don't vote for this. Well, that's garbage. There's lots of good people who don't sign blank checks. And then when he gets pushed, he tends to use the argument from authority. My expert constitutional group says this is fine. There's not a single skeptic of the voice on that expert constitutional group. And there's only one person who could remotely be claimed to be a conservative, which is Greg Craven. And he was one of the architects of this. So I'm a conservative law professor. I can tell you the law schools here lean left incredibly. There's maybe 3 or 4 of us in the whole country who teach public law who are, right of center. And
so, some of the debates where they've referred to this group of constitutional law experts, I think some of the things like, is it a third house of Parliament? Does it affect the notion of, I think it was ceding sovereignty and sovereignty? What are your views on that?
Well, look, I'm skeptical of the whole expert group. They're all committed to the voice. There's not a skeptic on the body. And if you ask a different question, are there any right of center people? There's one maybe, Greg Craven, but he's got confirmation bias in the sense that this was his baby in a way, and so people find it very hard to abandon shares they've bought or ideas they've come up with. And so I don't think that this expert body has really covered itself in glory. We know these terms are going to be justiciable. They're going to have to go to court and be decided by the unelected judges. Just bog standard practice, really. So there's problems right down the road. Now, you brought up one of the big problems, and that's the principle-based problem. And the principle-based problem is, in the year 2023,
which one?
We don't want a race-based provision in our Constitution. Now, some people will come back at this point and say, race is a pretty incoherent scientific principle. And that's right. So if you look at the extent of genetic difference amongst humans, it's tiny compared to, say, chimpanzees. And so you can, with a perfectly straight face and being scientifically literate, you can say, look, race is an incoherent concept. Nobody really understands what race is when it comes to humans. Fine. Let's talk about characteristics you're born with and over which you have no control. And then you could say, in brackets, and many people in a rough and ready sense just call that race, but it's not really race in any scientific sense. But so what? We don't want to have a constitution where things that you have no control over, like characteristics you're born with, give some group of people an extra say. And that's what this will do. It's very unpalatable. So in big picture terms, it's I think on principle, it's unpalatable. When it comes to what it will do, it's going to, in my view, lead to much more powerful unelected judges. Now, I've made a career out of being skeptical of judges. I don't trust them when it comes to confining themselves to doing what the elected parliament says. And so what we want to do is cabin their discretion. We want to keep them on the track, right? And even without this provision in our Constitution, and we have no Bill of Rights, which is good, I think, but even without a Bill of Rights, the judges have made up an implied freedom of political communication, and they've decided this Love case. And my view is that if we put this provision in the Constitution, it's like they're just going to be pointing to it and making up all sorts of things. Right. It's going to get its own chapter in the Constitution, and having your own chapter was one of the reasons for coming up with the whole separation of powers doctrine that limits Parliament. I don't really think much of that. I don't think it's a plausible interpretation of our Constitution. It's the basis for the implied freedoms. Again, I'm a big free speech guy. I don't think there's anyone more pro-free speech than me working in law schools. I'll mud wrestle them if they think they are. But the problem is that, you need honest interpretation. That's more important than first order substantive views. So there's real problems with this potentially unleashing judicial review. And I can remember in Canada in 1982, before the change, everyone said, we have the most conservative judges in the world. I mean, they mean interpretively conservative. Nothing's going to happen. That was true. And this new constitution came in. Canada's now judges are amongst the most adventurous activists in the common law world. They're completely unrecognizable. And once you go down the path, there's no going back.
That's right. So, part of my argument is that a lot of the genuine social and economic concerns for Indigenous people in the country can be addressed through legislation, and the argument against that is that over time that can be stopped or changed. But in actual fact, so the difference between a legislatively enshrined voice, for example, and a constitutionally enshrined voice is that one will go forever.
Well, it will go until you had another constitutional amendment to remove it. And can you imagine any political party in this country trying to trigger that referendum? It will never happen.
No, it'll never happen.
The Liberal Party in this country, they were in power 9 years. They couldn't even take on the ABC. They couldn't even cut the ABC's budget. The idea that they're going to trigger a second, if this turns to dust and it's terrible, they will never trigger another referendum.
No.
Now, you're right. You could certainly have a voice body that was set up by statute. And we've gone down that path before. There's all sorts of bodies for Aboriginal peoples. And there's no answer to that. Why don't we do it by statute? It would be quite uncontentious then.
Absolutely. Absolutely, that's
You know,
right.
the answer to
The
that
very
is,
fact that
oh,
they've
it's,
evolved,
yeah.
gone, been polished up historically,
You know,
closed down as a normal process.
you get this lame, weak response where they go, oh, it's symbolism. It's symbolism. We put it in the Constitution. It's symbolic. It's also very dangerous.
Mm.
Again, you know, we have a very successful Constitution. It's like the fourth oldest in the world, and it's
Tell me, you'd know better than I'm assuming that in the history of the development of, say, constitutional democracy, there has been examples whereby certain groups have had um, greater powers of representation over the history of the development
well,
of
of course. I mean, when the American War of Independence happened, the Revolutionary War, if you went to the then immediately after that in 1783, you could go to Connecticut. You could only vote if you were in the Congregationalist church, and you had to be a man, and you had to own property. You know, the voting base in the U.S. when it first started was tiny, and the first reform bill in England, 1832, tripled the franchise from
Mm.
about 8% of adults to 24% of adults. I did the math for those people who've gone through an Australian school curriculum in recent years because I figure they can't do the math. But no, look, that's a joke. But look, yeah, historically, of course, it's true that democracy grew up slowly, and you know you don't get the first country in the world that gives the franchise to women is New Zealand.
Mm.
South Australia, the state was before New Zealand. That's like 1880s, I think. And there's a couple of American states like Wyoming and Nebraska where they gave the vote to women before anywhere. But the first country was New Zealand. Well, yes, that's all true. And what people forget is until World War One, a lot of men couldn't vote in Britain. You had to own property. This is only 100 years ago. You know,
That's
it was
right.
a property franchise. And so, you know, we've the democratic era has been we've slowly expanded it to an age-based test, 18 and over, you know, barring you being in a lunatic asylum or something, and you get to vote.
Well,
And
that's right, and that I think that as the evolution of democracy has occurred, there is one thing that we have learned that is sacrosanct, and that is that all adult citizens are equal under the law, and that creates a recipe.
for most purposes, you want that kind of default assumption. Um,
But does the voice challenge that?
well, yeah, I think it's a race-based test. I don't like it. I also don't like the fact that in practice it's likely to lead to judicial activism. I don't like the fact that in practice it's almost certain that this body will be deferred to by Parliament, or at least it'll have to be bought off. There'll be rent seeking. It'll be extremely difficult to pass legislation that the body is against. You know, it's possible in theory, but that requires political willpower and a backbone, and we haven't seen that from any right of center parties. It almost inevitably will lean towards the kind of policies that the Senate likes to approve: more spending, more bureaucrats, you know, because those kind of policies dish taxpayer money out more widely. And so you get, you know, two-bit little independent senators all saying yes, and you're going to get the voice body saying yes. And so in practice, that's another bad thing. I also think in practice that Parliament will have a very hard time, you know, standing up to it. We don't have any details. It
How
seems
does it go?
incredible to me that they would sign
Is
a
there
check.
any impact? There's been some debate of late about this concept of sovereignty and whether the voice has any impact upon.
Well, it
sovereignty.
might. It depends on how you know, your view of what's likely to happen. The voice itself won't undermine sovereignty, but it's quite possible that judicial interpretations of the voice down the road will nibble away at. It'll certainly nibble away at parliamentary sovereignty. And if you read some of the proponents of the voice, if you go back and look at some of their earlier writings, not all of them, some of them, they certainly see this as a stage on the way to some sort of greater sovereignty for Aboriginal people. I mean, again, to me, it seems sort of weird. We all, as you said, we all have like a massive collection of different sort of chromosomes and genes. And when someone stands up and says, you know, two of my grandparents oppressed the other two because, you know, you're from a mixed marriage, or one of my great great grandparents oppressed the other seven, it seems a bit silly to me. And, you know, we are lucky to be living probably the best time you could ever live to be a human being, at least if you're born into the West. And certainly it's the best time ever if you're a woman or you're in a minority group. And the idea that you want to go and sort of play the victim based on things that didn't happen to you, but happened to people you can trace your chromosomes back to, again, I don't know why people apologize for things that happened 100 years ago. If you didn't do it, I don't know why you're apologizing for it. And likewise, if it didn't happen to you, I don't know why you should ever get reparations or anything like that. The goal of a liberal democracy is the sort of Martin Luther King goal, where, and it's an aspirational utopian goal, but the idea is you judge people by their character, their work ethic, their moral character. That's what Martin Luther King said. He dreamt of the day when people would be judged by the quality of their character and not the color of their skin. And we want to go back. One of the weird things is that was the goal of left of center parties for decades, and now they seem to have gone down the identity politics road where they explicitly want to undertake these sort of statistical analyses of what percentage of reproductive organs are in the general population and what percentage of them are on corporate boards or in parliament. And then you go to skin pigmentation. And it's the whole diversity, identity politics. It's very malign. And it gets at the underlying sort of pillar of liberalism, which is sort of if you treat people as individuals and you don't treat them as little cogs in a bigger group based on reproductive organs or skin pigmentation, you'll notice that it's never viewpoint. No one ever says, look, there's no conservatives working in any Australian universities, so we need to have affirmative action for viewpoint. I'd still be against affirmative action, but there's it's a way bigger problem, universities having no conservatives. When I say no, I'm exaggerating, but there was a poll out of Harvard last year run by the students at Harvard where they had an anonymous poll of their arts and engineering professors. And so it was anonymous. And it came back that 1.4% of the lecturer professors said they were conservatives or right of center. 1.4%. And I just assume, I don't have any basis for this other than personal experience, but I think engineer professors are likely to be the most conservative part of the university. Maybe not the med school anymore. They've gone crazy too. But the lawyerly caste, we sold that pass a long time ago. So there are so many problems with this voice thing, and they're using moral blackmail.
What you're saying is introducing effectively race into the Constitution. I'm summarising is type of undemocratic. And
the answer they'll give to that is, there's already racial provisions. So Section 5126, and again, that was a provision that originally was there on federalism grounds, so that if one level of government gets to deal with passing laws aimed at a particular race, well, it was going to be the central government, except originally they excluded Aboriginals. So the states would have to deal with the Aboriginal population. And 1967 took out the other than the Aboriginal peoples, which made it a national matter. So post-1967, the federal government could legislate on Aboriginal matters. And usually the assumption was, to help them.
So as I understand that is the federal government can make laws for all races.
Well, that's what they said in 1901, although in practice they never did. Early on, it's pretty clear they wanted to keep out certain races because they were perceived to be undercutting the labor market. Not aimed at Aboriginals, probably Chinese, who knows. But, there were very few of those laws and it sort of became defunct. But it also meant that only the states could legislate, to help Aboriginal people. And they could pass any laws they want at the state level. Now, if you're a federalist, you might think this is a good idea. I think there were some concerns in the 60s about Queensland. So they made it a national matter. Remember, with federalism, effectively what you have with federal democracies, and they're the most successful democracies. They're the wealthiest, the US, Canada, Germany, Switzerland, they're all federal systems. What you do is you give some legislative lawmaking power to the center, and you give other legislative lawmaking power to the states, the provinces, the lander, the cantons, whatever you want to call them. And, our federal structures have been destroyed by an approach to federalism interpretation. The judges basically in this country virtually always give the power to the center. So we're the only federal system in the world where the states, for all practical purposes, do not have income tax power. Every other jurisdiction has income tax. And people hear when I say, it's a terrible thing. They go, oh, you don't want states to have income tax power. Well, here's how it works. If you go to Canada, some provinces have a lower, so everyone pays federal tax. Let's say the top marginal rate is 25%. And then each province can set its own rate for income tax. And so Ontario is high tax and Alberta is low tax. And the US, New York is high and Florida has no income tax at the state level. And what happens is there's competition. And what happens is if you are in an unsuccessful state that's massively overspending, you have to raise your own money. In Australia, we run a sort of Marxist, we have the highest vertical fiscal imbalance in the world. And so if Victoria stops all exploration for natural gas and it locks down its citizens, in my view, unjustifiably for like over almost a year and bleeds money, the other states just give them money. There's a formula. There are no incentives for good performance. So federalism is the idea that you delegate down to the lander or the states or the provinces certain areas of decision making, and they will come up with different answers. And that's the whole point of federalism, the competition of ideas. Australians, to me, I get it in my classes, they all seem to think, well, you should have the same rule for the whole country. But, that's not how federalism works. That's how an uber centralized France works. So when I got here, it wasn't too long before, Mr. Howard decided it'd be a good idea to have a national curriculum. Well, this is fine if you believe that the bureaucrats who set the curriculum are always going to be right. Certainly not my view of the world. I work in a university. The bureaucracy is terrible. Canada has 10 provinces and 10 different school curricula. Alberta has a very high, the students who come out of Alberta have very high results, and some of the provinces are terrible. And that puts pressure on the poor ones. US has 50 states. Some of the curricula are set at the county level. And so it's your underlying attitude to the world. If you think government often gets it wrong, why would you want one school curriculum for the whole country? I mean, do you honestly believe it's going to be a good one in practice? Our school curriculum, I'll be done in a second. Our school curriculum is one of the worst in the world. New South Wales, as I speak, has the fastest falling school results in the world. Since we've gone to a national school curriculum, things have gotten worse and worse and worse. Totally predictable. I predicted it. And yet Australians seem to go, and this is their attitude to federalism, you should have the same set of rules across the country. Well, that's a dumb view if you think that governments often, lock in bad rules. What you want is experimentation and competition of ideas. And the states that are misperforming and overspending and have to raise their own money through their own income tax will be punished by its own voters. I can tell you that if Victorians had to spend their own money and not Western Australia's money, the pressure on bad government would be a lot more. Right now, you can be completely incompetent, and the aggressively redistributive formula for GST, which basically is crazy in my view, just rewards the losers. Fine, I think that ship has sailed in Australia because basically when I'm teaching in Canada and the US, people are just instinctively federalist. They get that you get different outcomes in different parts of the country, and that has really good consequences. There's fewer civil servants per capita in Canada and the US and Switzerland. You think to yourself, how can you have more civil servants per capita in a system where there's just one level of government? Well, just come and work at a university and you'll find out. I work at universities and 68% of the payroll goes to people who don't teach and they don't research. They're bureaucrats because there's no competition. There's no other level of government saying, you guys are just wasting our money. So there's all sorts of underlying attitudes about the world that sit behind this whole question of the voice. And so you can have a debate on high principle of whether you want a race-based constitution. You can have a debate on the role of the judiciary and how activist it'll be, I think, a lot. You can have a debate on politics and what will happen in practice, bad. You can have a debate about who in their right mind signs a blank check when the leader of the opposition won't even tell us any of the details. He just says, well, you're not a good person if you don't sign this. It's just a matter of common decency. No, it's not. Common decency requires people to give details before you make decisions that are really important. You can have a debate about all the things we don't know, how difficult it will be to unwind. And in my view, it'll be impossible to unwind. So this is a bad, I don't know what details Mr. Dutton is waiting for. I don't know why he hasn't come out hard. Now, I'm a right of center guy. As I said, there's only about 4 of us teaching in all of the Australia in the sort of public law schools. We can't travel on the same plane. It's too dangerous. If the plane goes down, there's none of us. So I don't know what's going on. I want a little bit of backbone. I don't see it.
I'm conscious of your time. A quick question: the notion of recognition. I've never quite understood that. That is from the perspective that I would have thought that all peoples in Australia are recognised equally, or do we have to put? Is it like how do we? What is this concept of recognition? Are Aboriginal and Torres Strait Islander peoples recognised in the Constitution, or are other races recognised in the Constitution? Do we need to specify race? Does it?
Yeah, I mean, I think Australia has a good constitution. I think the original federalism constitution was good, and the judges have completely destroyed it. So, leaving federalism aside, we have a written constitution that's not emotive. It's not utopian. We haven't got the sort of stirring first 10 amendments to the U.S. Constitution, which amounts to their Bill of Rights, if you add in the 14th Amendment later. And it deals in utopian amorphous entitlements, and that just delegates power to the judges. We have a very sort of workmanlike recipe book-like constitution. Here's what the legislature is going to look like. We are going to have an upper house. The upper house will have, in effect, half the number of MPs as the lower house. And it sets out the judiciary, and it effectively tries, within the context of a written constitution, to create parliamentary sovereignty. It's a very democratic constitution. The idea is that all social policy debates will occur either at the state legislative level, if it's in the federal, if it's a federal power that goes to the states, or it'll go to the central, Canberra-based national parliament. And of course, you can have debates about federalism, but you're having debates between 2 elected bodies. Once you go down the road of having high-flowing sort of emotive entitlement provisions, what you're doing is you're taking things off the table for all the elected representatives, and you're handing them over to the lawyerly caste, from which you choose your 7 top judges. And they are massively out of keeping with the views of the median voter. The lawyerly caste is, there's lots of social science evidence of this. The high-level legal profession now is much more open to identity politics. The Love decision from 2020, where they were deciding the case based on otherness. It's like they were at a French deconstructionist seminar, and Mr. Foucault had wandered in, and the judges had listened too carefully. It's a terrible decision, literally terrible. It might be one of the worst reasons decisions I've ever read, and for my sins, I've read many. And so why would you want to give people who have those sort of fallibilities any more tools to work with? That's what the Voice will do. And so, I now my view is I'm very hopeful that this will lose. But you never know. You never know for sure. It's a mug's game to predict the future. But there have been 44 constitutional referenda in this country, and 36 have failed. Now, a lot of people say, it's really hard to change the Australian Constitution. And I think that's wrong if you mean the procedures for changing it. If you look at the US or Canada, the procedure to change their written constitution is really hard. In the US, you need both houses of the Congress in Washington, and you need 3/4 of the legislatures. Now, you notice that in the US, the average person does not get any say in changing the Constitution. It's solely the political class. In Canada, likewise, the average person gets no say in the Constitution. It's the political class. If we had that rule in Australia, we'd be a republic. The whole political class is out of keeping with the average voter. That's part of the problem right now. In Canada, you need both houses of parliament in Ottawa, and then you need 2/3 of the provincial legislatures, provided that they represent over 50% of the population. That's for most things. But for some things, like changing the monarchy, it has a special, like there's about 10 of them that get special provisions. In Canada, to change the monarchy, you need both houses of parliament and all 10 provinces. So when people say to me, why does no one debate the monarchy in Canada? It's because it's impossible to change the Canadian Constitution. I mean, Prince Edward Island has 130,000 people out of 35 million. You know, the economy in Prince Edward Island is based on potatoes and the story Anne of Green Gables, because believe it or not, it's on the Japanese school reading list, and there's tons of Japanese tourists who go to Prince Edward Island to see the house where Anne of Green Gables would have lived had she been real, but she's not. But they've built a little fake one so that they get the tourists, you know, and they have a veto. And so, you know, in Australia, changing the Constitution is incredibly democratic. You vote, and if 50% plus one want to change it, that's leg one. And then leg two, you need 50% of the population in over half the states. That's the federalism leg. And as I said, 36 out of 44 have failed. And of those 36 failures, 31 failed because they couldn't get half their fellow citizens to agree. That is not a hard test. It means that most people like the Australian Constitution. Now, I've gone back and looked at all 44 referenda, and I would have agreed with the voters 42 out of the 44 times. And you'll hear these, and they're all left of center constitutional. It's so hard to change the Constitution. What they mean is, we don't like what the voters have delivered. And if we had the power, we would override the majority of Australians. And they don't like the fact that Australians, the sort of polity, the established list of voters, deliver answers that they don't particularly like. You know, there have been two referenda to try to bring in a Bill of Rights. Both have lost. The last one was in 1988, I think. And, 4 years later, the judges made up out of thin air this implied freedom of political communication, because many of those judges wanted a Bill of Rights. So they just made one up. You know, it's much more limited than a Bill of Rights. And, that's only ever led to, I think, 5 or 6 times that a statute has been struck down. But, it's a problem. And so we have a problem on that front. And I think, there's practical problems, there's principle problems, there's political problems. And maybe the worst thing is, this body is not going to unite Australians. It's going to be incredibly divisive. It's going to be divisive in so many different ways. Some people are going to push for more. They will not be satisfied. We see that from New Zealand. Other people will be bitter that a government ran this constitution without funding the no case and without telling us what was coming. And, if you think this is going to be a thing that unites the country, I just think that you're empirically wrong. It's going to be very divisive. There will certainly be a push for more. I don't know whether it'll be successful or not. So I'm not at all in favor of this. And we're doing what we can. People who are against need to have a little bit of backbone. If someone calls you a racist, you just say, no, I'm not. I just believe in a proper working constitution. Don't be emotionally blackmailed. You have to recognize that the school system is has traveled so far down the identity politics road that your kids are effectively not getting both sides of the story at school. They certainly don't get both sides of the story at university. Now, there's some kids who think for themselves, and there's some kids who are cynical and they just say whatever they need to get a good mark. But we've got problems on a host of fronts, and the best way to start to push back is, firstly, we need to defeat this referendum. As I said, I'm moderately optimistic it'll go down.
James, I think we should call it quits there. That was just fantastic. It was really interesting to hear your insights.
Well, you sound like my mom, but thanks. The old joke when someone gets introduced that's a little over the top kind, you get up and you say, that's a great introduction. My dad would have loved to have been here to hear it, and my mom would have believed it. So we'll use that for that nice comment. Thank you.
Good. Thank you, James.
Thanks.